Hello everyone. So in this particularly segment, we are going to deal section 39 and section 40 of the performance of contracts. The contracts which must be performed. Now here the section 39 and 40 is very essential and very important to understand that contractual obligations need to be fulfilled. On the other hand, if we see section 40, where it mostly talks about the personal skills and the other important things, we'll be also discussing that too in detail. Now moving with respect to section 39, the effect of refusal of party to perform promise wholly. Now here the party who is not actually performing his contractual obligations may be refused to do his promise, and later we will find its effects. What's the effect that we suffered? So these things we will be discussing in this particularly point of aspect. Now effect of refusal of party to perform the promise wholly. Here we'll be discussing about that how the party is actually refusing the promise, that who is not fulfilling its contractual obligations. We'll be starting when a party to a contract has refused to perform or disabled himself from performing his promise in its entirety. The promisee may put an end to the contract unless he has signed by words or contracts conduct his acquiescence in its continuance. Okay, so here the promisee actually has the discretion to basically terminate or to end that contract if the other party is not basically fulfilling its contractual obligations or not fulfilling its contractual duties. Okay, if that particularly the party A, let's suppose if we take an example, party A and B, party A who is actually performing its contractual obligations, but the party B is not performing its contractual duties. Okay, now the party A has a right basically to terminate that particularly contract or to continue that contract in its acquiescence. Okay, so here is one word, that is acquiescence. We'll be discussing that too. But before that, unless he has signed by words or conduct. If party A has signed, okay, or by his conduct, is it might possible, okay, it looks like that B is has not actually obligated the contractual obligations, and it's still A is accepting that there is some kind of faults in the contract which the duties the B need to be fulfilled, but B is not fulfilling. Now the contract can go into its continuance. So this is the section which is trying to tell us about that the party to whom the option is available to end that or to terminate that contract at that moment is not ending that basically the contract, but the contract is going in its continuance. Okay, तो मैं अगर आपको समझाऊं तो भाई जो ए पार्टी थी उसके पास ये ऑप्शन था कि वो बेसिकली उस कॉन्ट्रैक्ट को उसी समय टर्मिनेट कर सकती थी, लेकिन वो जानते हुए भी, ठीक है, उस पार्टी को ये पता है कि भाई कॉन्ट्रैक्चुअल ऑब्लिगेशंस यहाँ पे फुलफिल नहीं हुई हैं, और वो कॉन्ट्रैक्चुअल ऑब्लिगेशंस जब फुलफिल नहीं हुई हैं तो उसके कारण क्या हुआ है कि वो कॉन्ट्रैक्ट वहां पे जो है पूरी तरीके से जो कॉन्ट्रेक्चुअल पेपर में बेसिकली जो टर्म्स एंड कंडीशंस लिखी थी वो फुलफिल नहीं हुई है। ठीक है, तो उसके बाद जो है कि पार्टी ए के पास ये ऑप्शन है कि वो बेसिकली उस पर्टिकुलरली कॉन्ट्रैक्ट को टर्मिनेट कर सकती है, या फिर वो चाहे तो उसको पता है कि भाई जो पर्टिकुलरली ऑब्लिगेशन जो ड्यूटीज हैं वो पार्टी बी नहीं निभा रही है, इज नॉट परफॉर्मिंग इट्स ड्यूटी, सो दैट कॉन्ट्रैक्ट कैन गो इनटू इट्स एक्विजिशंस। ठीक है, कॉन्टिन्यूएंस एंड एक्विजिशंस। अब यहाँ पे जो एक्विजिशंस वर्ड है, विल बी जस्ट ट्राइंग टू investigate this word because this is one of the very important word in this particularly whole section of 39. The means to accept or agree something passively without protest or obligation. नाउ द पार्टी ए उसको पता है कि भाई यहाँ पे जो कॉन्ट्रैक्ट है वो जो है कि कॉन्ट्रेक्चुअल ऑब्लिगेशन जो बी को परफॉर्म करनी चाहिए थी वो परफॉर्म नहीं कर रहा है, बी इज नॉट परफॉर्मिंग इट्स कॉन्ट्रेक्चुअल ऑब्लिगेशन, एंड बाय नोइंग दिस that party is not actually terminating the contract. So now the party A is not terminating the contract, so it means that contract is moving further आगे। ठीक है, तो प्रोसीड कर रहा है contract has not been stopped or not ended or not terminated. So this is, अगर हम उसको legal context, if we see the acquiescence in the legal context, what that means, it refers to the act of silently or implicitly accepting a situation or condition even if one might have had the right to object or oppose it. तो भाई वो जो पार्टी ए है नाउ ही साइलेंटली ऑब्जर्विंग एवरीथिंग, इज नोइंग दैट द पार्टी बी इज नॉट फॉलोइंग इट्स कॉन्ट्रेक्चुअल ऑब्लिगेशन, बट स्टिल बीइंग साइलेंट ओके ऑन दैट particularly the conditional situation of the contract. So they have the right basically to terminate, but it's not terminating, a is not terminating that particularly the contract. Okay, so उसको ऑब्जेक्ट नहीं कर रही है, जब उसके पास राइट टू ऑब्जेक्ट है तो तब उसको ऑब्जेक्ट वो नहीं कर रही है पार्टी ए, ठीक है. आई होप फ्रॉम दिस particularly the legal context you might be understanding how what we are discussing in section 39. And if I'll give you one example, if a party to a contract acquiesces in a breach or delay by not raising any objections or acting to terminate the contract, they are considered to have accepted the breach or delay even though they had the option to take the action. तो अब क्या है कि भाई जब that party is basically not sincere about terminating that particularly contract, okay, so after some time what will happen, the time will be lapsed, and when the time will be lapsed, okay, limitation जब वहां पे जब limitation period will be over, so that party will not have the right to basically to end that or to terminate that contract. Now I have actually discussed this in full detail, what is the meaning of acquiescence. And if I'll give you one more simple explanation with respect to this is, if one party refuses to perform or is unable to perform their part of the contract, the other party has a right to end the contract. So other party के पास right to contract है, तो इस केस में क्या है, the party A has a right to contract that to terminate or to end that particularly contract. But here by in his knowledge on his knowledge to A that B is not fulfilling its duties, obligation, contractual obligations. So here what's happening, सो यहाँ पे उस पर्टिकुलरली कॉन्ट्रैक्ट का एंड नहीं हो रहा है और कॉन्ट्रैक्ट जो है एक कॉन्टिन्यूंस में आगे बढ़ रहा है, ठीक है. हाउएवर द पार्टी हु इज अफेक्टेड बाय द रिफ्यूजल कैन नॉट एंड द कॉन्ट्रैक्ट, जो पार्टी उसको रिफ्यूज नहीं कर रही है, ठीक है, उसको रोक नहीं रही है उस समय, तो क्या है वो बेसिकली जो है कॉन्ट्रैक्ट जो है वो एंड में नहीं आ सकता है. इफ दे एग्री इधर बाय वर्ड्स और एक्शंस, अगर उनको लगता है कि एक्शंस या फिर वर्ड से, ठीक है, कि हमें उसको जो है कि कंटिन्यू करना है, उसको चलते रहना है कॉन्ट्रैक्ट को, उसको रोकना नहीं है, उसको टर्मिनेट नहीं करना है, सो दैट विल बी इन इट्स कॉन्टिन्यूएंस, ओके, इट विल नॉट स्टॉप एनी मोर. सो ये पार्टी ए को पता है, ठीक है. तो यहां पे जो है कि आप देख रहे हैं कि ब्रीच ऑफ कॉन्ट्रैक्ट तो हो रहा है, दैट पार्टी बी इज एक्चुअली डूइंग द ब्रीच ऑफ कॉन्ट्रैक्ट, इज इन्वॉल्व इन द ब्रीच ऑफ कॉन्ट्रैक्ट, बट ए इज स्टिल नोइंग द फैक्ट दैट बी इज नॉट परफॉर्मिंग इट्स ड्यूटी, द ए इन इट्स acquiescence of continuance. So in short, if one party doesn't fulfill their promises, the other party can cancel the contract. So दूसरी पार्टी जैसे बी पार्टी है वो अपना जो है कि कॉन्ट्रैक्ट्स के प्रोमिसेस को फुलफिल नहीं कर रही है, तो यहाँ पे ए पार्टी जो है उसको क्या कर सकती है, कैंसिल कर सकती है उस कॉन्ट्रैक्ट को बेसिकली, ठीक है. But if the affected party agrees to continue with the contract anyway, they cannot cancel it later. So I have told you that there would be the limitation period which will come, okay, and after just ending that limitation period you cannot cancel or you cannot rescind that particularly the contract, okay. So this section basically ensures, what this particularly section ensures, that a breach of a contract and the other party है ना doesn't immediately act to end it, then later they can't claim to have the right to terminate it. तो बाद में उनके पास वो राइट, जो राइट ऑफ टर्मिनेशन था, जो राइट ऑफ ऑब्जेक्शन था या फिर राइट ऑफ रिसेंडिंग था, वो नहीं रह जाता है, ठीक है. इट एक्चुअली गॉट ended, ठीक है. सो दैट राइट गॉट एक्चुअली डिसॉल्व, तो वो राइट उनके पास बाद में नहीं रह जाता है. आई होप आपको इसके explanations, in simple explanation I have given to you, so you can understand and correlate the things easily, okay. अब इसमें जो एक important case है सेक्शन 39 ऑफ इंडियन कॉन्ट्रैक्ट एक्ट 1872 के अंदर, वो है केके वर्मा वर्सेस यूनियन ऑफ इंडिया का AIR 1954 का लैंडमार्क जजमेंट है. सो थ्री थिंग्स विल बी डिस्कस इन दिस पर्टिकुलरली जजमेंट. द फर्स्ट थिंग इज दैट द केस emphasized that if one party refuses to perform their obligations, contractual obligations under the contract, the other party is entitled to rescind the contract. तो भाई अगर एक पार्टी अपनी ऑब्लिगेशंस को फुलफिल नहीं करती है तो दूसरी पार्टी के पास ये राइट है, कि वो उसको क्या कर सकती है, जो है रिसेंड कर सकती है, ठीक है. दूसरा क्या इंपॉर्टेंट चीज इसमें जजमेंट में क्लैरिफाई करा, वो क्या था कि द राइट ऑफ द एग्रीड पार्टी टू टर्मिनेट द कॉन्ट्रैक्ट इफ अदर पार्टी रिफ्यूजेस टू परफॉर्म देयर ड्यूटीज. सो दैट अदर पार्टी, दैट बी पार्टी इज नॉट परफॉर्मिंग इट्स ड्यूटीज, ओके, refuses to perform its contractual obligations. So here the right has been given to the party A, that the party A can basically terminate that particularly the contract. Now the third important thing that we'll be going to discuss here, if the aggrieved party continues to accept the performance despite the refusal. Okay, now here party A is actually accepting that particularly the performance, is not actually refusing that thing, and in the front of his eye, naked eye, he can see that B is not fulfilling its contractual obligations. So what will happen? So they may lose the right to terminate the basically the contract. So I've told you with respect to this example. Now I'll be talking to more important thing in short, that is recession. What is recession? Recession means the right to rescind, terminate. Recession means terminate. Okay, rescind. To rescind means to terminate. The contract is granted to the aggrieved party unless they show that they have acquiesced in the continuance of the contract. So right है पूरा ए पार्टी के पास कि वो उसको रिसेंड कर सकती है, ठीक है, जब तक वो नहीं दिखाते हैं कि भाई हम अपने एक्शंस या फिर अपने कंडक्ट से या फिर अपने वर्ड से या फिर अपनी कोई राइटिंग में कि भाई अब हम इस पर्टिकुलरली कॉन्ट्रैक्ट को आगे नहीं बढ़ाना चाहते, वी वांट टू टर्मिनेट दिस कॉन्ट्रैक्ट, वी वांट टू एक्चुअली रीसेंड दिस पर्टिकुलरली द कॉन्ट्रैक्ट. नाउ द इंपॉर्टेंट second word that is was acquiescence. Acquiescence in short, if I'll tell you that if the aggrieved party agrees to continue despite the refusal either through words or conduct, they may lose the right to terminate the contract. So this is the simple definition of acquiescence. Through the aggrieved party has the right to terminate the contract basically, okay, but in its acquiescence, knowing the fact that B is not performing its contractual obligations, they may lose the right to basically terminate the contract. So I hope we have discussed the section 39. Now we'll be moving further to section 40, which is very very important. Now the section 40, the person by whom promise is to be performed. Okay, section 40 tells about the person by whom the promise is to be performed. There will be a person by whom the promise will be performed. Okay, so if it appears from the nature of the case, so the nature of the case is very important in this section. What's the nature of cases? Okay, we'll be discussing different types of nature of cases, and that it was the intention of the parties to any contract that any promise contained in it should be performed by the promisor himself. The promisor will perform himself. Okay, such such promise must be performed by the promisor, and that promise should be performed by the promisor. The promisor, the person who has done that promise, okay, that I'll do something, so instant in return of the consideration, so that person has to perform that promise. Okay, and in other cases, the promisor or his representative may employ a competent person to perform it. Let's suppose in any case that particularly the promisor got some injury, okay, or some health issues. So instead of that particularly promisor, what he can do, he can appoint a representative employee. Okay, when he'll appoint his representative or a competent employee to perform that particularly the task, okay, or to perform that contract. So I hope I have given some kind of summary with respect to the section 40. Now moving with respect to detail in this section. This is one of the very important section to understand. Now one important thing that I just want to make mention here, the promisor. What do you mean by the promisor? The promisor is the person, okay, he is the person or a party who is committing to fulfill an contractual obligation. So he's a person who is actually fulfilling a contractual obligation in a contract or the agreement. So he is known as the promisor. So I told you that it appears from the nature of the case. Okay, what kind of basically the cases are formulating over there. So that depends. Now, here are some key important points. The first is that dependence on the personal skill or trust. So this is important, that promisor, if he has done a contract, he has came in a contract of with respect to the some personal skill or some trust, then that promisor has the legitimacy to perform that particularly the contract. Rather though that promisor can't that another man cannot perform that particularly the contract, who doesn't have that competency or that that skill, so he cannot perform it. Okay, the second important thing, there will be the no transferable performance. If that person who is only competent for a surgery, you cannot call another person for doing a surgery. So the competent person is doctor. You cannot call any other layman while performing that surgery in behalf of that doctor. So you cannot transfer that performance. You are appointed to perform that particularly the conduct. So you cannot go away from performing that conduct. So this is important. The promisor cannot delegate or assign the performance to somebody else. So you cannot